Good day, class. Welcome again to Criminal Law Book 1. And today I'll be discussing reading material number 2. So first on the list, we have the revised Penal Code for Act number 3815 as amended. So there are different names for laws in the Philippines. We have acts, second, Commonwealth Acts, third, Republic Acts, then presidential decrees, batas pambansa, and executive orders. So the revised penal code is not a Commonwealth Act, it is not a Republic Act, it is not a presidential decree, it is not a batas pambansa law, but an act. Okay, so therefore it's Act number 3815, not Republic Act number 3815, not Commonwealth Act number 3815, not Batas Pambansa number 3815, but Act number 3815. So acts are laws promulgated by the Philippine government under the United States sovereignty. So these laws were from 1900s to 1935. So ato mga laws nga na promulgate from 1900s to 1935 are called acts. And then Commonwealth Acts from 1935 to 1946. So example is the Commonwealth Act number 141 or the Public Land Act. Okay? And also from 1942 to 1945. Man siya, mga Commonwealth Acts na siya. Then Republic Acts na po, evolve na po siya into Republic Acts. So RAs or Republic Acts are presently those promulgated by the current government of the Philippines under the 1987 Philippine Constitution. So from 1946 to 1972. Okay? So RAs were also used but stopped when the infamous 1973 Constitution was promulgated. So up to present, RAs na itong use. Okay? So laws promulgated by the current government are called Republic Acts. Then presidential decrees, katuning ko Kamarcos. Okay? So presidential decrees or issuances that had the force and effect of law when the Philippines was under the Marcos regime or martial law regime. Okay, then batas pambansa were laws promulgated by the National Assembly under the regime of Marcos. So mga batas pambansa siya. Mga laws, okay, nga gi-promulgate sa National Assembly under the regime of Marcos or Marcos regime, like BP 22 or the bouncing check law. So mere issuance of a check na walay funds constitutes a violation of BP 22. Okay. And then executive orders. What are executive orders? They are executive issuances by President Corazon Aquino during her provisional dictatorship prior to the ratification of the 1987 Constitution. So executive orders at all that. So these were issued by virtue of her powers under the Freedom Constitution. So before 1987 Philippine Constitution, dapat gitawag nga Freedom Constitution. Okay, in the year 1986. So an example of this EO or executive order is EO 209, also known as the Family Code of the Philippines. Okay, so again, the revised penal code is otherwise known as Act number 3815. Why? Because it is a law promulgated by the Philippine government under the United States sovereignty. Okay, so laws from 1900s to 1935 are called acts. So question, the revised penal code is otherwise known as A, Act number 3815, B, Republic Act 3815, C, Act number 3815, or letter D. None of the above. So what's your answer? So correct answer is A. Act number 3850. Okay. So Article 1 of the Revised Penal Code. So it talks about time when the Revised Penal Code or Act number 3815 takes effect. So this code or the Revised Penal Code shall take effect on the first day of January 1932. Okay, that's why the effectivity date of the Revised Penal Code is on January 1, 1932, and it was passed into law on December 8, 1930. Again, passage into law December 8, 1930. But the Revised Penal Code only took effect uh, on January 1, 1932. Please take note. Okay. So, effectivity date of the Revised Penal Code. So, the Revised Penal Code took effect on A. January 1, 1932. B. January 2, 1932. C. January 1, 1930. Or letter D. January 2, 1930. Correct answer is A. January 1, 1932. That's the effectivity date of the Revised Penal Code. Third question. The Revised Penal Code was approved into law on or passed into law on December 8, 1930, December 8, 1932, C, January 8, 1932, or letter D, January 8, 1930. What's your answer? Correct answer is A, December 8, 1930. Okay, basis here. RPC took effect on January 1, 1932. So this is the effectivity date of the Revised Penal Code, and approval and passage into law December 8, 1930. Okay. So Article 2 talks about the application of its provisions. Okay, so except as provided in the treaties and laws of preferential application, the provisions of this code shall be enforced not only within the Philippine archipelago, including its atmosphere, its interior waters and maritime zone, but also outside of its jurisdiction against those who, number one, should commit an offense while on Philippine ship or airship. Second, should forge or counterfeit any coin or currency note of the Philippines or obligations and securities issued by the government of the Philippine Islands. Third, should be liable for acts connected with the introduction of these islands of the obligations and securities mentioned in the presiding number or preceding number. Number four, while being public officers or employees should commit an offense in the exercise of their functions. Or number five, should commit any of the crimes against national security and the law of nations defined in Title 1 of Book 2 of the Revised Penal Code. So Article 2 talks about application of uh, the provisions of the Revised Penal Code. So it can be applied uh, intraterritoriality or extraterritorial. So outside, as long as it would fall on the five exemptions. So Article 2 of the RPC, Revised Penal Code, has two scopes of application. We have number one, intraterritorial application. So this pertains to the uh, application of the Revised Penal Code in the Philippines archipelago. So under the intraterritorial application, the Revised Penal Code is enforceable only within the Philippine archipelago, within the Philippine territory, including its atmosphere, interior waters, and our maritime zone. However, as an exemption, we have the extraterritorial application, which means that the Revised Penal Code can be enforced outside the Philippines, provided mo fall siya sa mga exceptions or the extraterritorial exceptions provided under Article 2 of the Revised Penal Code. So, what does the phrase "except as provided in the treaties and laws of laws of preferential application" mean? So, I'm referring to slide number 6. Okay, except as provided in the treaties and laws of preferential application. So, this phrase means that treaties, agreements, okay, between states entered within countries, laws of preferential application takes preference over the provisions of the RPC. So therefore, if na a conflict between treaty, okay, entered into by the Philippines with another country, let's just say US, and if it is in conflict with any provision of the RPC, the said agreement shall prevail. Okay? So mas strong itong agreement kaysa sa RPC. That's why the treaties entered with countries like laws of preferential application takes preference over the provisions of the revised penal code. So example, so this is the Larrañaga case. So based on the revised penal code, a person who is convicted of a crime shall serve his sentence in the New Bilibid prison, the National Penitentiary. That is, however, the Philippines entered into an agreement, a treaty with Spain, and this agreement was ratified by the Senate. So ratified meaning approved by the Senate. And as a result thereof, after Larrañaga has been convicted of kidnapping and serious illegal detention with rape and homicide, considering that he has two citizenship, a Filipino citizenship and Spanish citizenship, he was brought to Spain, and there he is serving his sentence. And because based on that agreement, Spanish citizens who are serving their sentence in the Philippines can be brought to Spain, and they are to serve their sentence there. So mo to'y gipili ni Larrañaga to serve the sentence in Spain. Okay, so Larrañaga to advantage because definitely mga facilities dito sa Spain or prison facilities dito is much better, okay, compared to Philippines. So extraterritorial application. So there are 5 instances where the revised penal code shall take effect outside the Philippine territory. So as a general rule, the revised penal code is enforceable only within the territory. That's the territoriality characteristic of criminal law. However, the exceptions, the extraterritorial application of our revised penal code. So number 1 is those who commit an offense while on a Philippine ship or airship. Let's just say, while on a Philippine ship or airship, nangawat ka, nga kay gisumbag, serious physical injuries, nangawat, so theft, okay? So, mo-apply ang revised penal code mo. Because the revised penal code, book 2, punishes the crime of theft and serious physical injuries or physical injuries. Okay? So, when is a Philippine ship or airship considered of Philippine in nature or registered in the Philippines? So when is it a Philippine ship or airship? When can you consider a ship or airship Philippines or belong to the Philippines? Answer, if it is registered in the Philippines and under Philippine laws. So if registered sa Philippines, ang usa ship or airship, it's called a Philippine ship or airship. So even if totally or wholly owned by a Filipino citizen, if it is not registered in the Philippines, wala pag Filipino ang tagian na if wala na registered sa Philippines ng ship, dili na siya matawag og Philippine ship or airship. Because it is only upon registration that this aircraft or vessel can fly the Philippine flag. Therefore, it is the registration which is the operative act which makes it a Philippine ship or airship. Okay? So it does not matter if totally or wholly owned by a Filipino citizen. Okay? If it is not registered in the Philippines, it is not a Philippine ship or airship. Dapat registered sa Philippines ang ship or airship to be considered a Philippine ship or airship. So this is a situation where a crime committed on board a Philippine vessel while it is outside the Philippine territory, but not in the territory of another country. So while in transit and wala pa ni dunggo sa territory sa another country. So applicable. Okay, so extraterritorial application of the revised penal code. Okay. So question, if a Philippine vessel is on waters of the Philippines and a crime was committed on board, what country will have jurisdiction? Again, if a Philippine vessel is on the waters of the Philippines, napasulod sa waters of the Philippines, wala pa kagawas. okay, and a crime was committed on board, let's just say theft, okay, punishable under the revised penal code, what country will have jurisdiction? Obviously, the Philippines. Lisulod pa mas atong territory. Second question, what if that Philippine vessel is on the high seas or international waters and the crime was committed on board the said Philippine vessel? What country will have jurisdiction over the said crime? Still the Philippines, because of the extraterritorial application of the revised penal code, Article 2 of the revised penal code. Okay? And it is the situation where Philippine ship is outside the Philippine territory, but not in the territory of another country. Okay? If na-commit nga crime while on a Philippine vessel, but inside the territory of another country, so that's a different scenario na po. It requires a different answer. Okay? So, third question. What if the Philippine vessel is on the waters of Malaysia, Nanas territory sa Malaysia, and a crime was committed on board? What country will have jurisdiction? Of course, the Malaysian courts will have jurisdiction because of the territoriality characteristic of criminal law. Okay? And we have exceptions. So if the vessel is a Philippine war vessel, mga warships na to, or mga warplanes, Philippine warplanes, they are considered an extension of the Philippine sovereignty. So miskan pag naa sila sa territory sa Malaysia, sa US, etc., applicable ang atong criminal law. Okay? Applicable, in force, because that's the exception. Because as a rule, a Philippine warship or war aircraft is considered an extension of the Philippines or Philippine sovereignty. Okay? So, miskan pag nasa sa territory sa Malaysia or US, applicable Japan ang revised penal code nila. Okay? So, wherever they may be, when a crime is committed on board a Philippine warship or war vessel or warplane, the Philippines will always have jurisdiction. And the reason is the first paragraph of Article 2 of the revised penal code, that it is the intraterritorial application of the RPC because it is as the crime is committed within the Philippine territory. Because Philippine warship and warplane are considered extensions of the Philippine sovereignty. So there are two jurisdictional rules for merchant vessels, mga foreign merchant vessels. So we have the French rule and the English rule. So under the French rule, it states that crimes committed aboard a foreign vessel, sulod sa foreign vessel, foreign merchant vessel, within the territorial waters of a country are not triable in the courts of such country. Okay, that's the general rule under the French rule. However, we have an exception. When the crime committed affects the public order, the peace and security of the host country, ang country na nag-receive nila, okay, then the host country will have jurisdiction over the said crime. So if dili ra mo affect sa public order and peace and security of the host country ang crime nga na-commit sa foreign merchant vessel, okay, wala sila jurisdiction ra. But if mo affect na gani sa public order, peace and security of the host country ang crime nga na-commit sa sulod sa foreign vessel, then the host country will have jurisdiction over the said crime. Okay, that's under the French rule. So English rule. So this talks about territoriality na. That's why the Philippines adheres to the English rule. So under the English rule, it states that when a crime is committed on board a foreign merchant vessel while on the waters of another country, it is the host country which will have jurisdiction over the crime. Okay? What are the exceptions? So when the crime merely affects the internal management lang of the vessel, of the foreign merchant vessel, then it is the flag country. Flag country meaning kung asa na registered to nga vessel, which mo to yung na jurisdiction. So in effect, the English rule is territorial in nature. Okay, so that is why the Philippines adheres to the English rule because of its strict territorial nature. Okay? So again, we adhere to the English rule. So under Philippine jurisdiction, we follow the English rule. Thus, it has been held in the case of U.S. versus Luke Chow that mere possession of opium aboard a foreign merchant vessel in transit is not triable in the Philippine courts because the act alone does not constitute a breach of public order. Mere possession naman of opium while on a foreign merchant vessel, and according to the Supreme Court, the act of possessing opium aboard a foreign merchant vessel does not constitute a breach of public order. Therefore, under the English rule, let's go back. When the crime merely affects the internal management of the vessel, then it is the flag country which will have jurisdiction. Ug asa na register to nga vessel ug asa gikan to nga vessel, motoy mo kuwag jurisdiction, not the Philippines. Okay? So however, okay, smoking opium, mag-smoke na kag-opium aboard a foreign merchant vessel is considered to be a breach of public order because it causes such drug to produce harmful effects within the territory. So mag-smoke na ka, so katong smoke mo cause daw harmful effects within the territory. Therefore, triable na siya sa Philippine courts katong nag-smoke. Okay? So that's the English rule. So, example, a foreign merchant vessel is on Manila Bay and a crime was committed on board the Philippines. The Philippines will have jurisdiction over the said vessel and criminal because we follow the English rule. Example, katong nag-smoke siya. Therefore, Philippines will have jurisdiction. Smoking opium. So, questions. So, crimes committed aboard a foreign vessel within the territorial waters of a country are not triable in the course of such country. In criminal law, this principle is known as, okay, letter C, French rule. Crimes committed aboard a foreign vessel within the territorial waters are not triable in the course of such country. So, exceptions, katong ma-affect na ang public peace, etc. So, second question, crimes committed aboard a foreign vessel within the territorial waters of the country are triable in the course of such country. In criminal law, this principle is known as the English rule. Exception, exception, when a crime merely affects the internal management of the vessel, like possession of opium. Okay, so second exception, we have those who forge or counterfeit any coin or currency note of the Philippines. Okay, so if you will counterfeit the coins of the Philippines or monies of the Philippines nga naka sa Japan, of course, mo apply ang criminal law nato. Okay, so there can be an extraterritorial application of our revised penal code sa Japan o asa ka nag-forge o counterfeit. Okay, third, those who should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the presiding number. Okay, so if you mo itong i-import, okay, you will be held liable. Okay, if you are liable para i-introduce sa Philippines katong mga obligations and securities katong mga kwarta nga gi-forge, okay, you'll be held liable. Covered ka sa extraterritorial application of criminal law. So, question. So, X was in Japan. He counterfeited Philippine coins. He then introduced these coins to the Philippines. Although the crime has been committed in Japan, he can be held liable before Philippine courts. This is necessary in order to maintain and preserve the financial circulation and financial stability of the Philippines. Otherwise, no country would be interested in prosecuting him except the Philippines because it is only the Philippines which will be affected by the said counterfeiting of coins. Therefore, extraterritorial application. So forth. So those who, while being public officers or employees, should commit an offense in the exercise of their functions, as long as the offense was committed in the exercise of their functions. So this refers to public officers who are working in another country. And while working there, they committed a crime. So the crime committed by these public officers must be in connection with the exercise of their function. Katuning sa mga embassy sa gawas na nagtrabaho. So if the crime they committed is not connected with the exercise of their functions, then they should be prosecuted in courts of the country where they are assigned. If not connected, okay, with the exercise of their functions. But if connected with the exercise of their functions, ang crime na ilang na-commit, of course, the Philippines will have jurisdiction. But if not connected, ang mo-prosecute nila is ang courts of the country where they are assigned. So example, an OFW lost his passport. He went to the Philippine Embassy in Japan, applying for a new passport. He has been going there back and forth, okay, that it was not yet approved. Okay, wala pa na-release Japan. On his way out, he saw the approving authority. He talked to Mr. AA, requesting and begging him that it be immediately approved and released. So he was invited to a coffee shop. While having coffee, AA asked for $500. Okay, and promised on the same afternoon his passport would be released. So the poor OFW gave $500 to Mr. AA, the approving authority. So where may AA be prosecuted? Is it before the Philippine courts or before the courts of Japan? Of course, AA may be prosecuted before the Philippine courts because ang nakomit na crime ni Mr. AA, the approving authority, was in connection or is in relation in the exercise of his official functions. Okay? So, let's move on. Same examples lang po siya. So number 5, let's proceed to number 5. So those who should commit any of the crimes against national security and the law of nations, even if outside the country, naragya po yung extraterritorial application ng atong revised penal code. So crimes against national security includes what? Under the revised penal code book 2, we have treason, conspiracy, and proposal to commit treason, mga misprision of treason, or espionage, like spying. So if any of this crime is committed, even if it is done outside the Philippine archipelago, the offender can be prosecuted before the Philippine courts na. Okay? So memorize the exception, the extraterritorial exceptions, Article 2 of the Revised Penal Code. So next is about crimes committed against the law of nations. So we have inciting to war, violations of neutrality, correspondence with hostile country, flight to enemy's country, piracy, qualified piracy, mutiny, and qualified mutiny. Okay? Don't worry. Ma-encounter ninyo sa Revised Penal Code book 2 na. Okay? So let's not dwell on this right now. Let's just focus on book 1. So examples. A, B, C, D, and E are in America, and they decided to overthrow the government of the Philippines. And in preparation of their plan, they bought guns, ammo, grenades. However, before they can proceed with their plan, they got caught. Now, can A, B, C, D, and E be tried in the Philippines? The answer is no. Their crime is conspiracy to commit rebellion, not treason. Okay? Which is a crime against public order. Conspiracy to commit rebellion is only a crime against public order. Therefore, dili siya covered. It is outside the said crime is outside the scope of the extraterritorial jurisdiction of the Philippines. Same example only. So that's the end. So thank you very much for listening. Good night.